I found the letter from the California State Water Resources Control Board buried in my mailbox between two credit card offers, and for a moment I thought it was just another piece of bureaucratic nonsense. But when I tore it open, standing there in the scorching June heat, sweat already dripping down my back at 10 in the morning, I realized my entire world was about to implode. The letter was dense with legal language, but 3 words jumped out at me like they were written in fire: water rights violation. I read it twice, then 3 times, my hands shaking so badly the paper rustled. According to the State Water Board, someone had filed a complaint that I was illegally diverting water during a drought emergency. Me, Logan Xavier, third-generation owner of a 480-acre ranch in Kern County, California, supposedly stealing water I had been legally using since my grandfather filed the original appropriative rights back in 1952. I drove my truck up the dirt road toward my property line, the one that bordered what used to be empty scrubland owned by some investment company out of Los Angeles. Except it was not empty anymore. Where there had been nothing but sagebrush and rattlesnakes 2 years ago, now stood row after row of terracotta-roofed houses, each one practically identical to the next, spreading across the hillside like a rash. 200 homes, according to the massive sign at the entrance. Desert Vista Estates, luxury living in the heart of California. I had watched them build it, of course. Hard to miss construction crews and cement mixers for 18 months. But I had never paid much attention. My ranch was doing well enough, my cattle had water, and I figured more neighbors meant the county might finally pave some of these roads. I was an idiot. The drought had been getting worse every year. What used to be a reliable creek running through my property had slowed to a trickle, then dried up completely by April. I had been relying entirely on my water rights from the underground aquifer, the same rights my grandfather had secured 70 years ago. The same rights that were apparently now in question. I pulled up to the gate of Desert Vista Estates, where a security guard sat in an air-conditioned booth, looking bored. He was maybe 22, wearing a uniform that was too big for him. "Help you?" he asked through the window. "I need to speak to whoever runs your HOA," I said. "I own the ranch next door." He looked me up and down, taking in my dusty jeans and work shirt. "You got an appointment?" "No, but I have a letter here from the state saying your development is using my water. So unless you want me to start making phone calls to every news station in Bakersfield, you will let me through." His eyes widened a little. He picked up a phone, mumbled something I could not hear, then nodded. "Community Center is straight ahead, 3rd building on the right. Mrs. Deborah Whitmore is the HOA president. She is there now." The streets inside Desert Vista Estates were pristine, lined with young palm trees that must have cost a fortune to install, and even more to keep alive in this heat. Every lawn was green, impossibly green given that we were in the worst drought in California history. Sprinklers ran on several of them, shooting arcs of water into the air at 10:30 in the morning during peak evaporation time. My jaw clenched so hard my teeth hurt. The community center was a sprawling building designed to look like Spanish colonial architecture, all white stucco and dark wood beams. Inside, the air conditioning hit me like a wall of ice. A woman sat behind a reception desk, her blonde hair pulled back in a tight bun. "I am here to see Deborah Whitmore," I said. "And you are?" "Logan Xavier. I own the ranch your development was built next to." Her expression shifted to something between pity and contempt. "One moment." She picked up her phone and spoke quietly, then pointed down a hallway. "Second door on the left." Deborah Whitmore was exactly what I expected. Mid-50s, perfectly styled auburn hair, wearing a cream-colored pantsuit that probably cost more than my truck payment. She stood behind a large desk in an office decorated with photos of the development, awards from various homebuilder associations, and a large map of Desert Vista Estates on one wall. "Mr. Xavier," she said, not offering her hand. "I wondered when you might show up. You know who I am?" "Of course. You are the rancher who has been illegally diverting water from the aquifer that serves our community." She sat down and gestured for me to sit as well. I remained standing. "That aquifer has been serving my family's ranch for 70 years, I said, pulling out the letter from the water board. "I have legal appropriative water rights filed in 1952. What I want to know is how your development got built without anyone checking those rights first." Deborah folded her hands on her desk, her smile never wavering. "Mr. Xavier, I think there has been a misunderstanding. Desert Vista Estates conducted extensive geological and hydrological surveys before breaking ground. We have our own water rights, properly filed and approved by all relevant authorities. Your ranch is pulling from the same aquifer. Yes, but your usage has become excessive during the drought period." "Excessive?" "I am using the exact amount I have always used. I have cattle to water, crops to irrigate. You built 200 houses that did not exist 2 years ago, each one using water for lawns, swimming pools, and whatever else, and you are telling me I am the problem." "Our development includes state-of-the-art water recycling systems," she said, her voice taking on a lecturing tone. Every home has low-flow fixtures and drought-resistant landscaping requirements. I pointed out her window at the nearest house, where sprinklers were still running. That does not look drought-resistant to me. Her smile tightened. Some homeowners are still in the adjustment period. We have an education program. You filed the complaint with the water board, didn't you? The HOA filed a complaint. Yes. Our engineers determined that your excessive pumping from the aquifer is causing our wells to run low. During a drought emergency, we have a responsibility to protect our community's water supply. I leaned forward, putting my hands on her desk. Your community has existed for 6 months. My ranch has been here for 3 generations. I have legal water rights that predate your development by 70 years. You cannot just show up and claim I am stealing water that has been legally mine since before your parents were born. Deborah stood up, her expression hardening. Mr. Xavier, I suggest you retain legal counsel. The HOA has already filed suit in county court to have your water rights reduced or eliminated based on current drought conditions and public necessity. 200 families depend on that water now. Your cattle operation serves only your personal profit. Public necessity? You are not a city. You are a luxury housing development. We are a planned community serving the housing needs of Kern County residents. The law is quite clear that public water needs supersede private agricultural use during emergency drought conditions. She walked to her office door and opened it. I think we are done here. You will be hearing from our attorneys. I wanted to argue more, to tell her exactly what I thought of her and her plastic community, but I could see it was pointless. I walked out, my boots echoing on the tile floor, past the receptionist who would not meet my eyes, and back into the blazing heat. My truck thermometer read 106 degrees. I sat in the cab with the engine running and the AC blasting, trying to think. I was not a lawyer. I was a rancher. I knew cattle and hay and water management, not property law and appropriative rights doctrine. But I knew I needed help, and I knew I needed it fast. The law office of Martinez and Chen was in downtown Bakersfield, squeezed between a bail bondsman and a tax preparation service. I had found them through a Google search for water rights attorney Kern County, and they were the only ones who could see me that same afternoon. Sarah Chen was younger than I expected, maybe 35, with sharp eyes and a no-nonsense handshake. She listened while I explained everything, occasionally taking notes on a yellow legal pad. "Do you have documentation of your water rights?" she asked when I finished. "Everything. The original filing from 1952, every renewal, survey maps, well logs. My grandfather kept meticulous records and so did my father." "Good. And you have been using the water continuously since 1952? "Every year. We have never let the rights lapse." She tapped her pen against the pad. "Okay, here is what you are facing. Under California law, water rights are complex and highly dependent on the specific facts. Your appropriative rights from 1952 are valuable, but they are not absolute. During drought emergencies, the state water board has broad authority to curtail water use, and courts have increasingly ruled in favor of municipal or community water needs over agricultural use. But they are not a municipality. They are a private development, true, but they serve residential purposes. Courts tend to favor domestic water use over agricultural irrigation when resources are scarce. The legal term is beneficial use, and drinking water for homes generally ranks higher than irrigation for commercial farming. I felt my stomach drop. "So I am going to lose?" "I did not say that. Your rights predate their development by 70 years. That matters. What we need to prove is that your use is reasonable and that their development should have accounted for existing water rights before construction. If they built without proper investigation of prior rights, that is their problem, not yours. How do we prove that? We subpoena their development records, environmental impact reports, water surveys, geological studies, permits from the county. If they cut corners or ignored your rights during planning, we can demonstrate they created their own crisis." "How long will this take?" she grimaced. "Water rights litigation in California can take years, but given the drought emergency order, we can probably get an expedited hearing, maybe 6 months to a year." "I do not have a year. My cattle need water now. If they cut off my access, I am done. They cannot cut off your access without a court order. Keep using your water exactly as you always have. Document everything. Every gallon pumped, every head of cattle, every acre irrigated. We need to show your use is consistent with historical patterns and not excessive." I signed a retainer agreement that made my bank account cry and drove home as the sun was setting, painting the dry hills the color of rust. My ranch house sat at the end of a long driveway, a simple structure my grandfather built in 1949. It had never seemed small before, but compared to the houses at Desert Vista Estates, it might as well have been a shack. My phone rang as I was heating up leftover chili for dinner. Unknown number. "Mr. Xavier, this is Wendy Vance. I live in Desert Vista Estates and I really need to talk to you." I almost hung up. "If you are calling to harass me about water, you can tell your HOA president to go through my lawyer." "No, please, it is not like that. I am calling because I think what the HOA is doing is wrong, and I have information you need to see. I paused. What kind of information? Can we meet somewhere? I cannot talk on the phone, and I cannot be seen with you. We agreed to meet at a diner off Highway 58, halfway between my ranch and Bakersfield. I got there first and took a booth in the back, ordering coffee I did not want just to have something to do with my hands. Wendy Vance arrived 20 minutes later looking nervous. She was maybe 40 with brown hair and tired eyes, wearing jeans and a t-shirt. She slid into the booth across from me and ordered water. "Thank you for meeting me," she said quietly. "I am taking a risk even being here." "A risk from your OA?" She laughed bitterly. "You have no idea how bad it is there. Deborah Whitmore runs Desert Vista like a dictatorship. I have gotten 3 violation notices in the past month for things like my trash cans being visible from the street and having the wrong shade of beige paint on my window trim." "So why did you buy there?" "My husband got transferred for work. We needed a place fast, and it looked nice. We did not know what we were getting into until after we closed." She pulled a folder from her purse. "But that is not why I am here. I am here because I used to work in civil engineering before I had kids. When I heard about the lawsuit against you, I started looking into the development's water permits, and something did not add up." She opened the folder and spread out several documents. "This is the environmental impact report filed with Kern County before construction began. See this section on water resources?" I scanned the pages. The language was technical, full of terms like sustainable yield and aquifer recharge rates. "It says the aquifer can support the development's projected water use," I said. "Right, but look at this footnote." She pointed to a small notation at the bottom of page 47. "It mentions existing agricultural use in the area but claims it is minimal and would not impact development water needs." "Minimal? I run 300 head of cattle and irrigate 90 acres. "Exactly. I pulled your property records from the county assessor. Your ranch is listed as a working cattle operation with significant acreage under irrigation. There is no way a proper survey would classify that as minimal." She pulled out another document. "And this is the geological survey commissioned by the developer. It estimates the aquifer's capacity, but look at the date." I checked, March 2021. "So what?" "So the drought emergency order was declared in October 2020. But this survey uses hydrological data from 2018 and 2019, before the drought got severe. They based their entire water plan on outdated information that did not account for drought conditions." I stared at the documents. They knew the aquifer could not support both the development and my ranch during a drought, so they just pretended my ranch did not exist? I think so. Or at least they minimized it enough to get their permits approved. The developer was a company called Prestige Communities, Inc. They are based in Los Angeles, and they have built similar developments all over Southern California. They have a pattern of aggressive construction schedules and cutting corners on environmental review. "Why are you telling me this?" She looked down at her water glass. "Because it is wrong. You were here first. You have legal rights. And Deborah Whitmore has made it her personal mission to destroy anyone who questions the HOA's authority. She is already talking about assessing all homeowners $5,000 each to fund the lawsuit against you. That is $1 million in legal fees to take away your water. It is insane." I took the folder. "Can I keep these?" "I made copies. But please do not tell anyone where you got them. If Deborah finds out I talked to you, she will make my life hell." "I will keep you out of it," I promised. She stood to leave, then hesitated. "There is something else. The HOA has been having closed-door meetings about the water situation. I am not on the board, but my neighbor is, and she told me they are planning to drill a new well on the community common area, deeper than the existing wells. They think if they can tap into a lower aquifer level, they can bypass the shortage problem. That will drain the whole system even faster." "I know, but they do not care. They just want to protect property values and keep the development looking perfect." She pulled out her car keys. "Good luck, Mr. Xavier. I hope you win." I drove back to my ranch with the folder on the passenger seat, my mind racing. The documents Wendy gave me were explosive. If I could prove the development was approved based on fraudulent or negligent environmental review, I might be able to get their permits revoked, or at least force them to reduce water usage. I called Sarah Chen first thing the next morning and sent her scans of everything. She called me back an hour later, excitement clear in her voice. "This is good, Logan, really good. If we can demonstrate the environmental review was inadequate or deceptive, we can challenge the development's water permits. That shifts the entire legal landscape. How fast can we move on this?" "I will file an amended response to their lawsuit today. And I will also file a separate complaint with the State Water Board about permit fraud. This is going to get messy." She was not kidding. 3 days later, I found a notice taped to my gate. It was from Deborah Whitmore and the Desert Vista HOA. informing me that I was trespassing on community property every time I accessed my well, which was apparently now within 50 feet of their property line according to a new survey they had commissioned. I called Sarah immediately. "They cannot do that," she said. "Your well has been in the same location for decades. Property lines do not just move. Tell that to their surveyor. Bring me the notice. We will add it to the case file. They are getting desperate, which means we are on the right track." But the harassment did not stop. 2 days after the survey notice, I found my cattle water troughs had been drained. All of them. 6 troughs spread across my grazing land, each one bone dry in the middle of a heat wave. I called the Kern County Sheriff's Department and waited an hour and a half in the sun for a deputy to show up. He was sympathetic but not helpful. "Unless you have proof someone did this, there is not much I can investigate," he said, walking around the empty troughs. "Could be vandalism, could be a leak, all 6 troughs developing leaks on the same night, and look here." I pointed to fresh tire tracks in the dirt near one of the troughs. "Someone drove out here. He took some photos, but I could tell he thought I was wasting his time. I will file a report. If it happens again, call us immediately." It did happen again. 4 days later, someone cut the power line to my main well pump. The electrician I called said it was a clean cut, done with bolt cutters, not an accident. Another sheriff's report, more photos, no suspects. I started sleeping in my truck near the well site, a shotgun on the seat next to me. I was not going to let them destroy my ranch without a fight. The preliminary hearing for the water rights case was scheduled for late August, almost 3 months after I received the original letter from the water board. Sarah filed a mountain of motions and exhibits, including Wendy's documents about the fraudulent environmental review. The day before the hearing, I got a call from a number I did not recognize. "Mr. Xavier, this is Robert Chen from the California Department of Water Resources. I am calling about the complaint filed regarding Desert Vista Estates and their water permits." My heart jumped. "Yes? We have completed a preliminary investigation based on the information provided by your attorney. I am calling to inform you that we are suspending Desert Vista's Class A water permits pending a full review of their environmental impact report and geological surveys." "What does that mean exactly?" "It means they cannot pump water from the primary aquifer until we verify their permits were properly obtained. The discrepancies in their EIR are significant enough to warrant immediate action, especially given the current drought emergency." I wanted to cheer. "How long is the suspension?" "That depends on the review process. Minimum 30 days, possibly longer. They can apply for emergency temporary permits, but those will be subject to strict usage limits." I thanked him and immediately called Sarah, who was equally thrilled. "This is a huge win," she said. "It validates everything we have been arguing. When the judge hears about this tomorrow, it completely changes the dynamics of the case." That night, my phone started ringing non-stop. Blocked numbers, unknown numbers, numbers from Los Angeles area codes. I stopped answering after the 5th call where someone screamed obscenities at me before hanging up. Then my email started filling up with messages. Some were from Desert Vista residents supporting me, saying they had no idea the HOA was doing this and they thought it was wrong. But most were hateful. Threats, insults, accusations that I was trying to destroy their community and tank their property values. One email said my ranch should burn to the ground. I forwarded the threatening ones to both Sarah and the sheriff's department, then shut off my phone and tried to sleep. The courthouse in Bakersfield was packed. Apparently, water rights litigation during a historic drought attracts media attention. I counted 3 news cameras and at least 2 reporters I recognized from local TV stations. Deborah Whitmore sat on the opposite side of the courtroom with a legal team that included 4 attorneys in expensive suits. She gave me a look of pure hatred when I walked in. The judge was a woman in her 60s named Patricia Morrison, with a reputation for being fair but tough. She listened to opening arguments from both sides, flipping through exhibits and occasionally asking pointed questions. When Sarah presented the evidence about the suspended water permits, Deborah's lead attorney, a slick-looking man named Richard Fowler, objected immediately. "Your Honor, the permit suspension is a separate administrative matter and has no bearing on this case, which concerns historical water rights usage." Judge Morrison looked at him over her reading glasses. "Counselor, when one party's water permits are suspended for potential fraud, I would say that absolutely has bearing on a case where that same party is accusing the other of illegal water usage." Motion denied. Sarah spent the next hour walking the judge through the environmental review documents, showing how prestige communities had minimized my ranch's water use and based their permits on outdated drought data. She also presented evidence of the harassment I had experienced, including photos of the cut power line and drained water troughs. Judge Morrison took notes throughout, her expression unreadable. When it was Fowler's turn, he argued that my water usage had increased during the drought, making it excessive regardless of my historical rights. He presented pumping records that purported to show I was using 30% more water than in previous years. Sarah was ready for that. Your Honor, may I cross-examine on these pumping records? Proceed. Sarah approached the witness, one of Desert Vista's water engineers, with a stack of documents. Mr. Palmer, these pumping records you provided cover the period from January 2024 to June 2025, correct? Yes, and you claim they show Mr. Xavier increased his water usage by 30%? That is correct. Are you aware that Mr. Xavier purchased an additional 40 head of cattle in March 2024? Palmer hesitated. I did not have that information, so you did not account for the fact that his herd size increased, which would naturally require more water. Well, no, but... And are you aware that in April 2025 a wildfire burned approximately 30 acres of Mr. Xavier's pasture land, requiring him to irrigate emergency grazing areas to prevent total feed loss? I was not aware of that specific event. So your analysis of his water usage did not account for documented changes in his operation that would explain increased usage. I based my analysis on the data available to me. Sarah turned to the judge. Your Honor, the data available to him was incomplete and cherry-picked to support a predetermined conclusion. Mr. Xavier's water usage is entirely consistent with his historical rights and operational needs. The defense's argument is based on faulty analysis. Judge Morrison made another note. I will take that under advisement. The hearing lasted 6 hours. By the end, I was exhausted and starving. Judge Morrison announced she would issue a written ruling within 30 days. Outside the courthouse, reporters swarmed me with cameras and microphones. I gave a brief statement saying I was defending my family's legal water rights and I believed the truth would prevail. Sarah pulled me away before they could ask follow-up questions. You did great, she said. The judge was clearly skeptical of their arguments, especially after the permit suspension came up. What happens now? We wait. In the meantime, keep documenting everything. Keep using your water normally, and call the sheriff immediately if there is any more harassment. I drove home through the fading daylight, feeling cautiously optimistic for the first time in months. Maybe this would work out. Maybe the judge would see through Deborah's lies and protect my rights. That optimism lasted exactly 2 days. I woke up at dawn to the sound of machinery, heavy machinery close to my property line. I pulled on jeans and boots and drove my truck toward the noise, my stomach sinking as I got closer. 3 drilling rigs sat just inside Desert Vista's fence line, maybe 20 yards from my property. Workers in hard hats were setting up equipment, and a supervisor was directing operations from a pickup truck. I parked and walked to the fence. What are you doing? The supervisor turned. Drilling new wells. You got a problem with that? Those are going to tap the same aquifer my ranch uses. He shrugged. Not my concern. I got permits and work orders. You want to complain? Talk to the HOA. I took photos and video of everything, then drove to the community center. Deborah's car was already in the parking lot. She was in her office, typing on a laptop. She did not look up when I walked in. Your drilling rigs are going to drain the entire aquifer, I said. Our engineers determined we need supplemental water sources to serve community needs, she replied, still not looking at me. We have all necessary permits. You just had your permits suspended by the state. Those were our primary permits. These are emergency drought permits approved just yesterday, perfectly legal. I stepped closer to her desk. You are doing this to force me out. You know if you drain the aquifer, my cattle operation dies. She finally looked up, a thin smile on her face. Mr. Xavier, I am simply ensuring my community has adequate water. What happens to your ranch is not my concern. Now please leave before I call security. I wanted to flip her desk over. Instead, I walked out and called Sarah from the parking lot. They got emergency permits? She said. Incredulous. How? Their main permits are suspended for fraud. Apparently the emergency permits are different. Can they do this? Unfortunately, yes. Emergency drought permits have a lower approval threshold, but we can challenge them. Let me make some calls. The drilling continued around the clock. I could hear it from my house at night, a constant grinding rumble that never stopped. I watched my well levels drop day by day. What had been a reliable water source for 70 years was being bled dry in front of my eyes. My cattle started showing signs of stress. I had to reduce their grazing area and supplement with expensive trucked-in water. My feed costs tripled overnight. Sarah filed an emergency motion to halt the drilling, but the judge denied it, saying Desert Vista had a legitimate claim to emergency water access pending the resolution of the main case. I felt like I was drowning. My savings were disappearing into legal fees and water costs. The ranch that had supported my family for 3 generations was dying, and there was nothing I could do about it. Then Wendy called me again. I have something else, she said. Can you meet me at the same diner? This time she brought her laptop. We sat in the same booth and she opened a folder with dozens of email printouts. I hacked into the HOA's email server, she said quietly. Or rather, I guessed Deborah's password. It was her daughter's name and birthday. Not exactly high security. Is this legal? Probably not. But what I found is explosive. She spread out the emails. Look at this. 2 months before they filed the lawsuit against you, Deborah was corresponding with a commercial real estate developer from Phoenix. They want to buy your ranch and turn it into an expansion of Desert Vista. Another 300 homes. I stared at the emails. There it was in black and white. Deborah discussing property values, zoning changes, potential offers. And in one email she wrote, "The rancher will never sell voluntarily. We need to force the issue through water access. Once his operation fails, we can acquire the land at distressed pricing." She planned this, I said slowly. The whole thing. The lawsuit, the harassment, the drilling. It was all designed to bankrupt me so they could buy my land cheap. Wendy nodded. And look at this one. She is getting a finder's fee from the developer. $200,000 when the sale closes. She is personally profiting from destroying my ranch. Yes, and she never disclosed this conflict of interest to the HOA board or the homeowners. We are funding a lawsuit that benefits her personally while she told us it was about protecting community water. I took photos of every email with my phone. Can I use these? I do not know if they are admissible in court since I obtained them illegally. But maybe they can point your lawyer in the right direction for legal discovery. I hugged her. Thank you. You have no idea what this means. Sarah's reaction was equal parts excitement and frustration. This is fraud, conspiracy, breach of fiduciary duty, probably a dozen other things. But you are right that we cannot use illegally obtained emails directly. However, we can file a motion for discovery requesting all communications between Deborah and outside real estate developers. If she deletes the emails after we request them, that is destruction of evidence, which is a crime. She filed the motion the next day. Deborah's attorneys fought it hard, claiming it was a fishing expedition with no basis. But Sarah argued that the pattern of harassment and the suspicious timing of the drilling created reasonable grounds to investigate potential ulterior motives. Judge Morrison ordered limited discovery, requiring Deborah to produce all communications with real estate developers or commercial interest related to my property. 2 weeks later, Sarah called me with news. She deleted them, Sarah said. All the emails Wendy showed you. Deborah wiped her entire email server the day after we filed for discovery. Can we prove it? Her IT guy rolled over. He kept backup logs showing when files were deleted. He did not want to go down for obstruction of justice. So what happens now? Now we go to the judge and request sanctions for evidence destruction. And I am also referring this to the district attorney's office for potential criminal charges. The next hearing was tense. Deborah sat stone-faced while Sarah presented evidence of the deleted emails and the IT logs proving intentional destruction of evidence. Fowler tried to argue it was routine server maintenance, but the judge was not buying it. Mrs. Whitmore, Judge Morrison said, did you or did you not order the deletion of emails responsive to a court-ordered discovery request? Deborah's face was pale. Your Honor, I was advised by counsel that I am asking you a direct question. Did you delete emails? Yes, but they were personal communications and not relevant to. That determination is for the court to make, not you. Judge Morrison's voice was sharp. You do not get to decide what is relevant after being ordered to produce documents. She turned to Fowler. Counselor, your client has seriously undermined her credibility before this court. I am imposing sanctions of $50,000 payable to Mr. Xavier for destruction of evidence. I am also granting Mr. Xavier's motion to compel production of all backup data and server logs from Desert Vista's email system. Deborah's face went from pale to red. She leaned over and whispered urgently to Fowler, who tried to object, but the judge cut him off. Furthermore, Judge Morrison continued, I am ordering an independent forensic examination of the HOA's financial records to determine if there are any conflicts of interest relevant to this case. The examination will be paid for by Desert Vista HOA. When the forensic accountant's report came back 6 weeks later, it was devastating. Not only did it confirm Deborah's arrangement with the Phoenix developer, but it also revealed she had been embezzling HOA funds. Small amounts at first, a few thousand here and there for administrative expenses that were actually personal purchases. But over 2 years, she had stolen nearly $120,000 from the community. The report also showed that the $1 million legal fund she had created to fight me was never properly approved by a vote of the homeowners as required by the HOA's bylaws. She had simply imposed the $5,000 assessment on her own authority. The story hit the local news that evening. I watched from my living room as a reporter stood outside Desert Vista Estates, explaining how the HOA president had embezzled funds and potentially conspired to force a neighboring rancher into bankruptcy for personal profit. My phone rang. It was Wendy. Did you see the news? She asked. Just watching it now. There are police cars at the community center. They arrested Deborah an hour ago. Fraud, embezzlement, conspiracy. I heard she is looking at felony charges. A bunch of homeowners are filing a class action suit against the HOA board for mismanagement. And the developer, Prestige Communities, released a statement saying they are cooperating with investigators and denying any knowledge of Deborah's plan. Of course they are. Logan, I am sorry for what you have been through. A lot of us had no idea what was happening, I know. Thank you for your help. I could not have done this without you. After I hung up, I sat in the quiet of my house, watching the sun set over the dry hills. I felt tired down to my bones. The fight was not over yet, but at least the truth was coming out. Judge Morrison issued her final ruling on the water rights case in October, 5 months after I first received that letter from the water board. It was a complete victory. She ruled that my appropriative water rights from 1952 were valid and took priority over Desert Vista's permits. She also found that the development had been approved based on a fraudulent environmental review and ordered the State Water Board to conduct a full investigation. More importantly, she issued an injunction limiting Desert Vista's water usage to essential domestic purposes only. No lawn irrigation, no decorative fountains, no pools. The community's usage was capped at 50% of their current level until the aquifer recovered to sustainable levels. The property values in Desert Vista crashed. Homes that had sold for $700,000 were now worth maybe $400,000, if you could find a buyer. The HOA dissolved in a mess of lawsuits and recriminations. Most of the board members resigned. Deborah was indicted on 15 counts of fraud and embezzlement. The drilling rigs were removed and the emergency wells were capped. Slowly, painfully, my well levels started to recover. It took almost a year, but eventually the aquifer recharged enough to support my ranch again. Prestige Communities went bankrupt trying to defend against multiple lawsuits from homeowners, the state, and environmental groups. The land they had owned for the planned expansion was sold at auction. I thought about buying it myself, just to make sure it stayed empty, but I could not afford it. Instead, it was purchased by a conservation group that turned it into a wildlife preserve. Deborah pleaded guilty to avoid trial and got 3 years in state prison plus restitution orders for the money she stole. I attended the sentencing hearing and watched her cry as the judge read out her sentence. I did not feel satisfaction, just exhaustion. The homeowners of Desert Vista eventually formed a new HOA, with much stricter rules about transparency and financial oversight. Wendy was elected president. She called me to share the news. "We are trying to do things differently," she said. "Actually following the law, imagine that. Good luck. You are going to need it. I wanted to ask you something. Would you be willing to meet with the new board? We want to work out a good neighbor agreement. We know we are stuck with limited water, and we want to find a way to coexist without more lawsuits." I thought about it. I could have said no, could have told them to leave me alone after everything they put me through. But Wendy had risked a lot to help me, and not everyone in Desert Vista had been part of Deborah's scheme. "Okay," I said. "Let's talk." We met at a neutral location, a coffee shop in town. The new board consisted of Wendy and 4 other homeowners, all of whom seemed genuinely apologetic about what had happened. "We want to start fresh," Wendy said. "We know you were here first and you have rights we have to respect. We also know our development used bad data and cut corners. That was not fair to you or to us. What are you proposing? A water sharing agreement? We document exactly how much each party is using, and we set up a monitoring system so everyone can see the aquifer levels in real time. If there is another drought, we have a predetermined plan for proportional reductions instead of fighting in court. And what is in it for me? We pay for the monitoring system and the ongoing water quality testing. We also pay for half the cost of a new well on your property, deeper and more efficient, so you have a backup source if the main aquifer gets low." It was not a bad offer. I talked it over with Sarah, who said it made sense and could save a lot of money on future legal fees. "One more thing," I said at our next meeting. "I want a conservation easement on my property legally recorded so it can never be developed, no matter who owns it in the future." Wendy nodded. "We can help you set that up. Actually, I think a lot of our homeowners would support that. They bought here because they wanted open space around them, not more subdivisions." We signed the agreement in December, almost 18 months after the whole nightmare started. The local paper did a small story about it, framing it as a positive example of resolving water conflicts through cooperation instead of litigation. I did not tell them about the sleepless nights, the drained bank account, the stress that had me losing 20 pounds and developing an ulcer. I did not tell them about sitting in my truck with a shotgun, convinced I was going to lose everything my grandfather built. But it was over. My water rights were secure, legally documented and protected. My ranch was still operating. And I had a new well that could pump from a deeper aquifer layer if the shallow one failed. Life slowly returned to something approaching normal. I replaced the cattle I had been forced to sell during the crisis. The winter rains were good that year, the best in a decade, and the creek on my property actually flowed for the first time in 3 years. I saw Wendy occasionally around town and we would chat. She told me Desert Vista was adjusting to their water restrictions. Lots of homeowners had replaced their lawns with desert landscaping. Property values were starting to recover as people realized the community was actually implementing sustainable water practices now. We learned the hard way, she said, but at least we learned. One afternoon in early spring, I was out checking fence lines when I saw a car pull up to my gate. A young couple got out, looking uncertain. I drove over to see what they wanted. "Are you Mr. Xavier?" the woman asked. She was maybe 30. With friendly eyes. "That's me. We just moved into Desert Vista and we heard about everything that happened. We wanted to come by and apologize on behalf of the community. You did not have anything to do with it. We know, but still. We bought one of the houses cheap after the property values crashed. We knew about the water restrictions and the history. What Deborah Whitmore did to you was terrible." The man with her nodded. "We are trying to be good neighbors. We have a daughter and we want her to grow up understanding how to share resources and respect other people's rights." I felt something tight in my chest loosen a little. "I appreciate that. We brought you something." The woman handed me a basket. Inside was homemade bread, jam, and a card signed by about 30 families from Desert Vista. "It is not much, but we wanted you to know not everyone there is against you." After they left, I sat in my truck reading the card. Messages of apology, gratitude for not giving up my fight, wishes for good relations going forward. It was a small thing, but it mattered. That evening, I stood on my porch and watched the sun set over my land. The same land my grandfather had worked, my father had maintained, and I had nearly lost. The drought was not over, and water would always be a challenge in California. But my rights were protected now, legally and practically. I thought about Deborah, sitting in a prison cell, her life destroyed by greed and arrogance. I thought about the homeowners of Desert Vista, many of whom were innocent victims of her schemes, now stuck with properties worth half what they paid. I thought about Wendy, who had risked everything to do the right thing. The whole situation had been a disaster that never should have happened. A development built on fraudulent data, a HOA president using her position to line her pockets, 200 families and one rancher caught in the middle of a water war during the worst drought in California history. But somehow, through all the chaos and anger and legal battles, we had found a way forward. Not a perfect solution, but a workable one. My ranch survived. Desert Vista learned to live within their means. The aquifer was being managed sustainably instead of exploited. I went inside and poured myself a whiskey, toasting to my grandfather and father. They had built something worth fighting for, and I had fought for it. That was enough. The next morning, I woke up early and got to work. There were cattle to feed, fences to mend, a ranch to run. The same work my family had been doing for 70 years, the same work I would keep doing as long as I had water flowing from that aquifer and sun rising over those hills. Everything had changed, but the land remained, and I remained with it exactly where I belonged.